All right. Hello, everybody, and welcome to what is the second of a series of conversations that Emily Laidlaw and I are hoping to host around the Online Harms Act and its various attributes as it works its way through government. Today, we are going to dive into the two amendments that were added to this bill, to the regulatory model that we talked about in our last panel, the amendments to the Criminal Code and the amendments to the Canadian Human Rights Act. And we're going to dive into those, where they came from, what the implications of those changes are, and what we think should they remain or be amended in some capacity. I just I'm going to take a little bit of a backseat to this one as the one non-lawyer or legal expert on this panel. So I'm going to hand it off to Emily in a second to lead this conversation. But first, just to introduce this kind of amazing group we have here. Sanel Luc-Dermouch is assistant professor and assistant dean at the Faculty of Law at Western University, and has over a decade of experience as a human rights lawyer, for everything from the human rights tribunals up to the Supreme Court. Sandy Garacino is a national affairs columnist at National Observer and a former trial lawyer and Crown prosecutor. So we'll bring that view to this discussion. Richard Moon is a law professor at the University of Windsor and is one of Canada's leading experts on freedom of expression, and relevant to this debate in particular, authored the official report on Section 13 for the Canadian Human Rights Commission, which obviously weighs heavily in this debate about the Canadian Human Rights Act amendments, part of this bill. And Kenneth Grad is an adjunct professor and PhD candidate at Osgoode Law School, and his research focuses on the efficacy of criminal law to combat hate and racist speech. So this is a pretty wonderful group to dive in to what has been the subject of a lot of the debate about this bill. I mean, I think both to Emily and my somewhat surprise, the model that is the big regulatory model that forms most of this bill has received a lot less conversation than these Legal and Human Rights Act amendments. And so we're going to dive into that. And Emily, I'm going to pass it off to you in your more capable hands than I to introduce these amendments and then walk us through the conversation. So thanks, everybody.
Wonderful, thanks. Yes, and as Taylor said, about 90% of the controversy is only this kind of small 10% of the bill about the Criminal Code and Canadian Human Rights Act provisions, but they're important to discuss. And so I'm really looking forward to today. So to give a very, very brief overview of what is proposed for viewers. So the proposals are to amend the Criminal Code are to address essentially hate speech motivated crimes. So for one, there's an addition of an actual definition of what hatred means into the criminal code. I think that the 2 points of controversy would be that there's creation of a new offense, a new standalone hate crime that would apply to every offense in the criminal code and any other act of parliament. And it is for anything unlawful that is motivated by hatred, and the risk is life imprisonment. There's also now would be enabled a peace bond to be obtained, essentially in order to, keep the peace, where a person fears on reasonable grounds that hate propaganda or hate crime is about to be committed. And there's proposals to increase the sentences for hate propaganda offenses up to 5 years. And I mean, everyone can correct me if I'm wrong. If I recall, it's currently up to 2 years. Is that correct? And then up to life in prison for advocating genocide. And then the proposals to amend the Canadian Human Rights Act, Section 13, the hate speech provision, was repealed I can't even remember what year, 2012, 2013, somewhere around there. And it's looking to reintroduce to the Canadian Human Rights Act the ability to make a complaint to the Commission for hate speech. It is a different provision. It's much more narrowly defined, and that's something that we can talk about. And there is also some steps to limit frivolous complaints in the new provisions to the act, so we can discuss about whether that's enough, it goes far enough. So one would be that complaints can be dismissed where it is evident that it's not hate speech, and the other is that there can be an award of costs for abuse of process. So I think that's enough to get us kickstarted. And what I propose is we start with the criminal code provisions. And as I have mentioned separately, I do highly encourage everyone to just jump in as you want to have this discussion. You're all experts, and we'd love to hear from you. And so what I'll start with is a general question about the criminal code. And Kenneth, I'll turn to you. You know, we've had hate crime provisions in the criminal code for a long time. Are they working to address the problem? I mean, a huge question, isn't it? So are they working to address hate speech, and where are changes needed? I think that this is almost starting with, did we need this at all type of question with C-63.
Thanks so much, Emily. Yeah, it's a great question, a very big question. Absolutely. So yes, we have had sort of hate speech, hate propaganda provisions in the criminal code for a long time. Essentially, the kind of initial package of hate propaganda or hate speech offenses it was introduced back in 1970. So we've had it since then. And essentially, the main provisions are a provision that outlaws advocating genocide, a provision that outlaws the incitement of hatred, where that may lead to breach of the peace. A provision that outlaws the willful promotion of hatred. That's the one most frequently used. It was the most controversial at the time of its enactment. Perhaps remains most controversial. That sort of is more getting at really hate speech in and of itself. There's also a provision which is almost never used, which authorizes the seizure of sort of hate propaganda. So that's the package that we've had since 1970. There's also, just from 2022, so very recently, there's a new provision that outlaws the willful promotion of anti-Semitism, which is basically aimed at outlawing Holocaust denial. That's essentially what the provision gets at. We've only had that for a couple of years. It really tracks the language of this willful promotion of hatred provision, but it's a bit more narrowly focused on anti-Semitism and particularly Holocaust denial. And then the other thing I should probably note is that willful promotion of anti-Semitism, willful promotion of hatred, advocating genocide, they all require the consent of the Attorney General to invoke. So the Attorney General of the province or Attorney General of Canada. We also have a sentencing provision, which basically makes kind of bias, hate, prejudice, motivation an aggravating factor on sentence. So if someone is convicted of a crime, there's various things that a court can consider as an aggravating factor to sort of increase the sentence, and any kind of hate motivation is something that can be considered as well. So that's basically the sort of package that we have, and which I think these amendments are sort of designed to address. Are they working? Very good question. It's very tough to prove the impact of these things, right? But I think there's a reasonable sense that they haven't been working very well. I think that's sort of the broad consensus. Certainly hate speech is a much bigger problem now than it was in 1970. But that's, of course, for various reasons, whether that's because of the enforcement or lack of enforcement of the hate speech provisions, very, very difficult to say. But of course, there's been recent rises in recent years, particularly since the onset of the COVID-19 pandemic, in hate speech, hate crimes, right? Quite a shocking rise. What we can say is the hate propaganda provisions are not used very often. So sort of these ones that kind of get at hate speech, they're not used very often. The offense of advocating genocide, it's rarely used. I have some stats from StatsCan. I think there was only one finding of guilt between 1994 and 2019. So it's not something that is really used very often. This new offense, willful promotion of anti-Semitism, it hasn't really been, I don't think it's been used at all, to my knowledge. Someone can correct me if I'm wrong. And then even when they are used, so they're not used very often, and when they are used, the conviction rate has been relatively low. It's been quite tough to get convictions. So basically, we're not charging or convicting a lot of people under these provisions. And with respect to the sentencing provision that I mentioned, sort of this aggravating factor, my sense is the Crown and law enforcement have found it difficult to use as well, for various reasons, which we can kind of get into. But the bottom line is these provisions aren't being used a ton, particularly the hate speech provisions, which has given rise to the sense that sort of more was needed. Now, so were these particular changes needed? I mean, we can get into the content of the changes in question. Certainly from a political standpoint, there was a lot of pressure, I think, on the government to take action. And a lot of that pressure involved sort of increasing the penalties to give us, make it sort of so that people would get harsher punishment. It's a very common reaction that, we think if we just increase punishment, then people will take this more seriously. Also with respect to the sort of aggravating factor on sentence, I think law enforcement wanted more to be done. So now we have this kind of freestanding hate motivation offense, which again, we can talk about. So definitely, I think politically there's a lot of pressure, but as a matter of policy, I'm very skeptical personally about the criminal law's ability to solve the problem of hatred, hate speech, hate crimes. I don't think that any kind of inefficacy of the criminal law provisions was because of lower penalties or the lack of a standalone hate crime, things that this bill is introducing. My personal view is that the problems are really inherent in the criminal justice system. It's just not a good, I think, mechanism to combat hate speech. It's slow, it's cumbersome, it's expensive. It's not very good at changing people's views or actually stopping the offending behavior. And, just one of the things that's often cited is that this will have kind of a deterrent impact, right? If we sort of increase the penalties and charge more people, there'll be more deterrence. People will see this and they'll kind of refrain from engaging in hate speech. But we kind of know from sort of criminal law theory that certainty is much more better deterrent than severity of punishment. So just increasing penalties, I don't think is really going to get us there. So anyway, I'll stop now. I know I've gone on for a while, but my personal view is I don't think these changes were needed simply because I wouldn't really invest more resources into the criminal justice system, particularly in this area.
Well, and it's fascinating, and we'll turn to Sunil in a minute because there's also that public signaling function too of the law that something's wrong. Although with that specific offender, it might not have a deterrent effect or a deterrent effect more widely in society, it does signal to the protected group that that the law sees this as a wrong in some way. And I think that they talked about that in Keekstra, if everyone is wondering, the key hate speech case from the Supreme Court of Canada is that signaling function. If I recall, I haven't gone back to read it in a while. And there's also issues too with resourcing law enforcement, that the more that we ramp up the criminalizing effort, you also have resource constraints and training constraints of law enforcement that I think weigh heavily. And the Canadian Council of Academies wrote a report, Vulnerable Connections, that is worth reading. Everyone should read that because it kind of dives into some aspects of that, the beyond law issues here. But Sunil, let me turn to you because I'd love your perspective then on this question about what you think, and even that wider question about criminalizing hate speech and its effectiveness to address the issue and whether changes were needed to the criminal code.
Thank you so much, and thanks for having me. I got to start with a disclaimer in typical lawyer fashion. So these are my views, and they do not necessarily represent the views of the Ontario Human Rights Commission or the Ontario Public Service. I'm on leave from my position at the Ontario Human Rights Commission. So, hats off to Kenneth. Thank you so much for providing that foundational knowledge about the provisions. And I was looking at your paper, Kenneth, last night. This is what keeps me up at night. A Gesture of Criminal Law, Jews and the Criminalization of Hate Speech in Canada, 2022, Osgood Hall Law Journal. And you
It's
really,
sometimes more effective at putting people to sleep. Sorry.
yeah. So you really, you talk about the numbers, like how often are these hate propaganda provisions actually used or successfully used? So you looked at statistics, Canada's Integrated Criminal Court Survey between 2009, 2010, and 2017, 2018 fiscal years. There were 53 completed cases, completed being where there was a final decision in court or resulted in a guilty plea. This is an adult and youth court where the most serious charge was a hate crime offense. Those are mostly under Section 318 and 319, those hate propaganda offenses, but they also included mischief against religious property. So 53 cases, only 23 resulted in a finding of guilt, right? So in Kenneth's words, there haven't been widely enforced, and when invoked, the rate of conviction is low. The best illustrative example that I could give is the Sears case, right? From Toronto. So this was a 2019 decision, and it's the first conviction involving hate propaganda against women under the criminal code 319-2. And this is in 2019. These provisions have been on the books for decades, right? So two men behind a Free Toronto newspaper, Your Ward News, it was found to it promoted legalizing rape and denied the Holocaust, and they were found guilty of promoting hatred against women and Jewish people. And so when you think about that and you think about the dramatic rise in hate, and we know this, like, for example, the 2021 survey from the Canadian Race Relations Foundation, 1 in 5 Canadians indicated that they've experienced some form of, quote, online hate, harassment, or aggressive behavior. 40% of younger Canadians experienced or faced hateful comments or content online. And like, it gets worse when you consider more intersections, right? Let's talk about the lived experiences. In a 2022 national survey conducted for the YWCA and Canadian Race Relations Foundation, it found that more than 1 in 4 young women and gender diverse youth said they were personally targeted by online hate, and 1 in every 2 witnessed it. So clearly there's a significant gap. And, there are reasons for, lack of enforcement, right? We know that there's fractured trust between various equity deserving groups and police. And we know that some police have more resources than others. But yeah, I agree. These, provisions, they signal our values as a Canadian society, and the need to denounce online hate. And as a bit of a preview, yeah, I get it. The criminal code, that's reserved for the worst cases. A conviction under willfully spreading hate propaganda, it comes with a criminal record. It can include jail time. And that's why I think the bill's amendments to the Canadian Human Rights Act, which mean there's legal recourse for homegrown cyber hate that falls short of criminal behavior, that still seriously harms equity-deserving groups. I think that's why that is very important as well.
Well, so let's dig into then the specific provisions in the criminal code, because as you say, it really is focused on the worst of the worst. And this is something the Supreme Court has emphasized repeatedly in any of the hate speech cases before them. And so for one thing, what do you think, so, of the introduction of a definition of hatred into the criminal code? Do you think that was needed?
So I do think that's needed, right? It provides some real clarity. It's the criminal code amendments, the definition of hate, and same goes for the Canadian Human Rights Act. It defined hate speech in a manner consistent with Supreme Court of Canada jurisprudence, right? In Andrews, in Keekstra, the Supreme Court quoted Andrews. And Andrews said, to promote hatred is to instill detestation, enmity, ill will, and malevolence. Hate expression has to go a long way before it qualifies within the definition. And then later, hatred is predicated on destruction, and hatred against identifiable groups thrives on insensitivity. And then in Whatcott, the Supreme Court said speech that exposes a group to detestation, inspires enmity or extreme ill will, it must go beyond mere disdain or dislike. So that's right there in the bill. And so that's very important. It provides clarity, and that's great. But it also tells the public that we're dealing with a very narrow category of speech. You can still be offensive. You can still criticize vaccine mandates. You can still criticize affirmative action programs, access to sports for trans people. You can do all of these things. You just can't engage in this very narrow category of speech that dehumanizes people.
Well, and I was rereading the kind of 3 paragraphs of Keekstra yesterday that define hatred. And I think it is important for viewers to understand that, the bill is, as you say, is basically codifying what is current law in the Supreme Court by saying it has to be stronger than disdain or dislike, that is basically detestation and vilification. But it's not just those words interpreted on their own, detestation and vilification. It is within the context of all this jurisprudence that tells you what that means. I mean, it's still contextual. There's issues of kind of the subjective assessments, but that's also addressed by the Supreme Court to really push, criminalization of hate speech to an incredibly high threshold for legal, intervention. And,
it's an objective
maybe
standard.
we should then,
Right. It's
yeah.
an objective standard, right? Supreme Court has said, will the speech in question be interpreted by a reasonable person aware of the relevant context and circumstances as tending to expose members of the target group to hate? There's lots of expertise. There are the hallmarks of hate, markers of hate, which have been accepted by the Supreme Court. This isn't Justin Trudeau deciding what is hate. It's the courts and the Canadian Human Rights Tribunal.
Well, so then let's take a look at the new crime motivated by hatred. I know that this is probably the most, the AI for Zoom has really struggled. I don't know if you saw it, just maybe give a thumbs up to everybody. The new crime motivated by hatred. Sandy, I'd love you to kind of walk us through what substantively is proposed with this. It is controversial. What do you think about it? Do you think this is something that is needed, this amendment to the criminal code?
Well, when we have hatred already codified or already defined in the code, I think that's one of the key things. From a practical point of view, people calling the police and the police arriving to address a problem on a call, they want to be able to know, to have some kind of a handbook definition. The police have not, any police attending a call have not read Keekstra, I can pretty much guarantee. So having something that's codified in the criminal code, this is the police handbook. It is the charge approval handbook. Now, the offense motivated by hatred, this actually, of all of the amendments, in a sense, this gives me the most pause. So what it basically says is that everyone who commits an offense under this act or any other act of Parliament or any other act, so not even necessarily a criminal code offense, if the offense is motivated by hatred, and then it defines the groups, is guilty of an indictable offense and liable to imprisonment for life. Now, the keywords that any prosecutor is going to look at there are going, oh, this is an indictable offense. This isn't even what we would call a hybrid offense. Now, I'm sorry if I'm making everybody's eyes glaze over who's listening to this, but this is basically ramping this offense up to the highest level, and the accused person is liable to imprisonment for life. So automatically, procedurally, this will entitle a defendant to a preliminary hearing. So you are instantly clogging up the works in the procedurally. So you've got Crown are going to be, they're going to actually be reluctant to charge this because automatically they're going to, a defendant who, it might be shoplifting. It might be a shoplifting offense, but if it's motivated by hate, you know, we've seen how many of these terrible offenses that we were seeing on the street, just captured by CCTV cams of people pushing, hitting, doing all this sort of thing. Suddenly they are under this section, potentially liable for imprisonment for life. Now, we know procedurally that there are all kinds of sentencing guidelines, and that's not ever going to come into play really except potentially in a situation where someone has been killed and it's murder, that you'd ever see that. But from the practical standpoint, the line prosecutor's point of view is like, now I have to do many more things, and the accused is entitled to many more procedural, there are many more levels that have to be met. So that's going to, suddenly we're not anymore streamlining the criminal justice system, we're clogging it up. And one of the things that I feel about just generally speaking, from a practical point of view, it's human nature. Police, law enforcement, and everybody who is in the criminal justice system, resources are stretched. We already know this. So what happens? Everybody starts to try and shunt things, and shunting and minimizing are actually how a lot of these offenses get buried procedurally in the justice system, because everybody's overworked and this is hard, so let's just move it off our plates. And you see many examples, especially in the area of domestic violence, where people have just minimized and pushed offenses off to the side. And I think this happens a lot with hate crimes as well. And it's one of the reasons we have so few prosecutions, because it's just adding another layer. So generally speaking, I don't object to the idea of a standalone offense for an offense motivated by hatred. That's not the concern. My concern is that we should be looking where the criminal code is being used, except in the most extreme cases, and we have certainly had those in Canada, except in the most extreme cases, where you want to see the criminal code used, you want to see it used to de-escalate and deter. And I'm concerned that the reality of life in the prosecutor's office or in the law at the policing level, on the street level, this is not helpful. This is actually going to be difficult to administer.
Sandy, can I ask a quick follow there that around the sentencing for the standalone hate motivated crime? Mm-hmm. How would it be sentenced if it was on its own, not paired with another crime? Because the escalation to life is because if it was paired with something like murder, is my understanding, right? But so if that's the case, then what happens if you take it out entirely and just do it on its own? How does that work?
Well, the thing is that you can't, the way that this is drafted, and I'll defer to the professors on this panel. The way that this is drafted is that you can't take it out. The life imprisonment is part of and that's actual standard drafting. That the penalty is part of the definition of the offense. But that's the problem with the standalone. Now, the reality is that there are sentencing guidelines that strongly restrict any kind of discretion on this. Nobody needs to worry that they're going to get sentenced to life imprisonment for a minor offense that is made much worse by the fact that it is motivated by hate. we're not going to see life imprisonment for that. But this is where I would have, from a drafting point of view, I think I would have preferred to see this as a hybrid offense where it could be either summary conviction. I'm sorry, this is technical for the average
this is
person.
super important.
But summary conviction means that's like a shoplifting offense. So you're saying, well, the Crown has options here to proceed and treat this as a minor offense, or as it signals to everyone that there is a vast array of seriousness. Like it could be everything from shoplifting and a minor pushing incident to murder, and that this offense is going to target the hate element of that.
So I'm conscious of time, and I know no, it's not you, Sandy. This is exactly what we want, because I want to make sure we cover peace bonds before we also move on to the Human Rights Act. But I'm really interested to hear from you, Richard, about these criminal code provisions and whether you think that there should be this new crime motivated by hatred, whether it should be just abandoned or amended. So let us know your thoughts.
Well, I think I really only have a general observation, and that is how many of these peripheral provisions, and by which I mean the provisions that are not concerned what seems to be the core of this bill, and that is the duty placed upon platforms of different kinds. So many of them seem to really be about optics. And I think sometimes that can have value. So in the case of clarifying within the statute the definition of hate speech or hatred more generally in the various provisions, as Sunil mentioned, it is just about adopting the language that the court has used in elaborating the meaning of these various provisions. And so there's value in that. From a lawyer's perspective, it doesn't change anything, but it certainly, hopefully, it makes for greater clarity. But some of the additions, like attaching life imprisonment to different things, I just think are meant to signal on the part of the government, we take this very seriously. We recognize there's a real problem here and we are not underestimating it. But ultimately, and I think what Sandy's describing may well be counterproductive. And I think that's really unfortunate. I wanted to just add that these sections ultimately are very much peripheral because the core of the bill rests upon a recognition that these other legal responses maybe are just not going to be effective. There may be still a place, I think, for a criminal code ban on hate speech, but to deal with the most extreme, especially when we recognize that the duties placed on social media platforms don't attach liability to anybody, at least to those who post this material. And maybe there is a place for extreme and recalcitrant expressors of hateful views to be charged and prosecuted.
Well, and it's worth teasing out here, and I know this is something I've mentioned to you before, that we haven't talked about the Human Rights Act yet, but that report that you wrote, a key part of that was you said, look, there's actually a responsibility on platforms, on companies here to be dealing with these particular issues. Like that's the most effective place. And certainly, the core part of this bill is focused on what that responsibility of social media is. I mean, where I tend to land is I don't think that there should be any independent, if you're going to have a new crime motivated by hatred, fine. But it should never come with the prospect of life in prison. I think just from a messaging perspective, that is problematic in a free and democratic society to say that hate speech can result in life in prison. I understand the sentencing connection that is linking with murder. On a practical level, what I just haven't been able to understand is why you would actually then need that. I mean, if you're already going to prison for murder, perhaps, you might be sentenced to life in prison. What is the added value of life imprisonment for a hate-motivated offense? Sunil, you look like you're ready to jump in here. Is there something you were wanting to say, or am I misreading the expression?
I'm always ready to jump in. And, I do believe in the promise that the criminal code and related enforcement, can be effective, right? We've seen in the trial of the white supremacist who murdered the Afzal family. We've seen, I know that was a terrorism offense and murder and attempted murder, but there's the signal that sends and the message that sends to Canadians about clear denunciation. And I know there are different views about whether the criminal code or the Canadian Human Rights Act changes will be effective. But I brought up, for example, the Sears case, right? And then how that was the first one about hate speech against women, under Section 392 that was successful. But if we look, for example, at the changes to the Canadian Human Rights Act, so it's a lower standard, balance of probabilities. You don't need intent. Anyone can complain, and the complaint goes to the Canadian Human Rights Commission. Or if we think about, pre-2013, where the internet was, more in an emergence phase, or at least social media, there have been cases involving the internet that have portrayed Indigenous women as dispensable, people who are lustful, unfeeling, immoral, Black women as oversexed, animal-like, diseased, Muslim women wearing niqabs as terrorists who seek to destroy our society, lesbians as predators, and those were all successful. All of those examples I've just provided, those were successful. Those were resulted in findings under the Canadian Human Rights Tribunal. So I really believe in the promise there. I don't see these aspects of the system as necessarily unworkable. There's proof that it can work.
Yeah, and I think that what we have to think about what we're talking about when we say something's effective, right? That that link doesn't have to be that hate speech isn't going away, but what you're signaling is that there's an avenue of recourse to address what is seen as deeply problematic and harmful behavior, and that it can have an effect of perhaps reducing the amount of behavior, and if anything, providing a remedy in those circumstances and some accountability. And so before that actually is, it is a perfect segue at this moment to go straight to the Canadian Human Rights Act, because I think that that's a really important conversation. But I think we need to talk about peace bonds. I'm going to keep it brief because I see what the time is. And so I'm just going to talk to you, Sandy. And can you just walk us through this here? Because it has been labeled as criminalizing thought crimes. But I think that there is a need to understand what a peace bond is, how it's currently being used right now, and whether it's a wild proposition in the context of hate speech.
So the peace bond, I'll try and keep it short because I actually have quite strong feelings about this, having seen peace bonds used and used effectively in multiple cases. Getting back to the issue of de-escalation and deterrence, the public conversation around the peace bond aspect has gone wildly inflamed when, generally speaking, peace bonds really tone things down. Typically, the way that peace bonds are used right now and have been used historically and for hundreds of years is that when someone has reasonable grounds to believe that someone is going to commit an offense against them, these are commonly used in domestic dispute situations or stalking cases, this kind of environment where somebody has reason to have those fears, they can lay in information and under the current Section 810 and go before a justice and have a defendant brought before and enter into a voluntary set of terms that they're not going to say contact or harm or disturb the complainant. And that has worked extremely well. And the terms that are proposed here now are that a complainant can, with the Attorney General's consent, lay an information before a provincial court judge if the person fears on reasonable grounds that another person will commit an offense under Section 318, which is the standalone, I believe that's the which is the hate crime offense, or other subsections or other sections, all relating to hate offenses. So really, it's broadening the remedies that are in the criminal code right now. Peace bonds are extremely helpful tools that individuals can use, but they always are used with the consent of the Attorney General in practice, as far as I know, in Canada. So the Crown is involved in this, the provincial court judge is involved in this, and let me tell you, people don't get into court in front of people talk about this as if, oh, it's a prospective crime. You don't get in front of a provincial court judge unless something's already happened. It's actually used to stop more events happening, more crimes, and more escalation. And it's used actually to de-escalate and kind of tone everybody down. And all of the terms, the kind of penalties that are proposed, and the kind of remedies, the kind of controls that a provincial court judge can subject a defendant to here are generally, broadly speaking, already contemplated in the existing criminal code for other matters. They're just actually set out and cataloged in stronger detail, and therefore someone who violates their peace bond. So it's not like, oh, you can make a complaint and somebody's going to be brought in and they're going to be put under they're going to have to wear a monitor, an ankle monitor. That's for if they have entered into a peace bond and then they violate it. So it's for violations. So you're already in violation. So it just strikes me that this has really inflamed the public, but it's really about giving tools and remedies to the public who are already being victimized, and they are being victimized. We should be very mindful of those people who need to have some remedy that is going to be short of a criminal prosecution.
I mean, that is so helpful. Thank you, because I think that was a much needed reality check on what peace bonds actually are, and that this could be an incredibly important tool that's in fact in an effort to de-escalate, in an effort to prevent further harm, that it is in fact not here to criminalize thoughts. And in fact, it doesn't result in that. It's just using an existing tool in the criminal code to prevent some, further instances of hate speech or escalation. And thank you. And what we're going to do is we're going to move to the Canadian Human Rights Act. And I want to turn to you, Richard, to start, because I think that you of course, wrote the key report. You have a wealth of knowledge. You've read every single complaint that went to the Canadian Human Rights Act on hate speech. He's like, don't overstate this, please. But I'd love you to walk us through a bit about, a bit about the history of Section 13, the old one. I mean, why was it controversial? Some of this really has been distorted by politics over time. And so this is an opportunity to sort of to kind of reset this and clarify what actually happened, the repeal of it. Was this a process that was being abused? Were there a lot of complaints? What was the threshold for hate speech and so on?
Yeah. I mean, there's a long story, and I'll either try to say it quickly or leave out important parts as I go. So Section 13 was added to the Canadian Human Rights Act sometime after the introduction of criminal code provisions, and it was thought necessary to deal with some new forms of hate speech. In particular, hate messages on telephone lines. And there was a question of whether that met the publicness requirement that was in the criminal code. It probably did, but in any event. So originally it was just described as addressing telephonic communication, but of course then the internet came along and the section was expanded to include different forms of electronic communication, including the internet. So the original Section 13 has language that is similar to language in human rights codes in BC, Alberta, Saskatchewan, for example. And it prohibits communication that is likely to expose the members of groups defined on grounds protected under the Human Rights Code, but is likely to expose members of groups to hatred or contempt. So that was the basic language of the provision. There were, in fact, under the Canada Human Rights Act, which dealt with hate speech effectively online by the time it was repealed, there were not a lot of complaints. I think there were around 60 or something. I'm just giving very rough numbers. And almost a majority of those were filtered out early on by the Human Rights Commission. The remainder were investigated, some again dismissed, and only about 14 or 15 went to the Canada Human Rights Tribunal for adjudication. So here's the basic process. Somebody, a private individual, can bring a complaint to the Canada Human Rights Commission. The commission investigates the complaint unless it was trivial, vexatious, and made in bad faith. And if the commission, following an investigation, and investigations involved consulting with questioning both parties, that who had made the party made the complaint and the party against whom the complaint was made. So it was an investigation process that really did engage the parties and could go on for a period of time. In any event, if the commission decided that the complaint had real substance, they would refer the complaint to the Canada Human Rights Tribunal, an adjudicative body, to determine whether or not, following a hearing, the complaint, whether the provision, Section 13, had been breached. The principal remedy for breach was an injunction to cease and desist the behavior. There were also provisions related to costs and a provision that permitted the imposition, not very often used, of a penalty, but only in circumstances where it was shown that the individual was acting in a malicious fashion. Okay. What were the problems with it? Now, I think it's probably important to note that all of this occurred really prior to the rise of social media. So the provision is repealed in 2014. So most of what we're talking about was hate speech on websites that were in the margins of the internet, hate groups congregating, sharing views, encouraging one another in different ways. You wouldn't know about these sites if you didn't look for them. My concerns at the time with the provision were it put a huge burden on a complainant who had to see the complaint all the way through and play a significant role in the adjudication if that actually occurred. And it wasn't accidental that most complaints that actually went to adjudication were initiated by a particular individual who got very involved in the process, became very knowledgeable about it. So it put a huge burden on a complainant. And I think the other thing was human rights codes address principally discrimination, and they understand discrimination in very, very broad terms. And the process for addressing discrimination claims was not necessarily the ideal process for addressing hate speech understood in very extreme terms. And there were real issues about individuals who may not have engaged in hate speech. They may have engaged in bigoted speech of different kinds being pulled into this process, which could sometimes be prolonged, even though if ultimately the claim against them was dismissed without going to adjudication. So I think there were a variety of concerns like that. Now we have the new provision, and it does seek to address some of those things. It gives the commission more discretion to dismiss a complaint without going to an investigation if it thinks the complaint doesn't have real merit. So that gives them more leeway. And of course, the definition of hate and hate speech is more clearly defined as extreme, even though that's how the court interpreted it in any event, but it's now on the face of it within the statute defined to demonstrate that we're really talking about extreme speech. The concerns I have now, and I'll be interested what others have to say about this, really is how effective is this going to be? Any kind of prolonged process to deal with online hate, which spreads widely, it spreads quickly. I just don't see this being effective in addressing that. And the risk is there will be so many complaints that the whole process breaks down. We already have issues about the length of time it can take to process a human rights code complaint generally. And so it strikes me that's one problem. Or if there aren't a lot of complaints and the process is able to function, we still have the problem that it looks selective in character. It looks like it won't really address the problem. I'll add one more thing because I know we're running out of time. And that is when Section 13, its original version, was repealed in 2014, what really motivated, I think, that was a disinformation campaign that was conducted against the Human Rights Commission and against this particular provision. Various right-wing bloggers and so forth really made a variety of completely false claims about the cases that were coming before the commission, about the actions of the commission members and the employees of the commission, suggesting bad faith, suggesting corruption and so forth. Entirely false. And it was really unfortunate because those claims took hold and really came to define the debate.
No, that's perfect. Thank you, Richard. And one thing I want to turn to both Sunil and Kenneth. I want to hear from both of you on that. So I am paying attention to time. But one thing I'd love then is your responses and thoughts on all of it, on the idea of Section 13. But also, I mean, are there ways then to maybe contain the risks of an overwhelmed body? Separately, I did I work with the Law Commission of Ontario on defamation reform, and I was really obsessed with the idea of e-tribunals, online forms of dispute, and how do you contain a body from being overwhelmed. And some of it is, even just a small fee for a filing fee. I mean, there's an equity issue with that as well, but it can force people to really think through even a $50 fee about the decision to make that complaint, the detail that you maybe need in that complaint. But as you say already, Richard, it was already quite a burdensome complaint anyway, process. So I turn to the experts then here. Sunil, maybe start with you. Time-wise, I think we probably have about 8 or so minutes left total. So, give us your thoughts, and then we'll turn to you, Ken.
I'm going to let Ken go first because I don't want to dominate the conversation.
Thanks, Sunil. I don't think you've been dominating for what it's worth. So let me just, I'll try to be brief here, but let me just say I am, as I think you probably garnered from what I had to say about the criminal law at the outset, I'm supportive of non-criminal approaches to hate speech. And now that can actually include non-legal approaches, things like education. And the problem, I think, or one of the problems with getting rid of Section 13 back in 2014, so Section 13 of the Canadian Human Rights Act, is that it sort of ended up kind of filtering, I think, more things through the criminal justice system, putting more pressure on the criminal justice system. And I think victims don't always want to go that route. They don't always want to go the law enforcement routes, want something perhaps a bit less adversarial, the act of going and laying a charge, dealing with law enforcement. Some victims aren't interested in that. So I do think having sort of a non-criminal kind of avenue for these types of harms, I think is a good thing. And I think civil claims, I've sort of written about this as well, I think civil claims, and here I'm including human rights claims for group defamation, or sort of for hate speech, have several advantages over the criminal law, things like a lower burden of proof, the fact that truth is not a defense. So in the criminal law, truth is a defense. And what ends up happening is this can be sort of a source of kind of grandstanding for the accused who tries to prove the truth of their theories. Also in the criminal law, you have this kind of hyper focus on the intention of the accused, right? So what is the intention of the speaker? Were they willfully promoting hatred? Not something that's really the focus of the human rights tribunal, where the issue is really the damage to the victimized group. So I think rather than kind of a hyper focus on punishing the offender, a human rights tribunal can offer sort of a better way of focusing on how do we kind of repair the damage to the victimized group. Also, the human rights route can be a little bit more flexible in terms of remedies. Things like ordering a cease and desist order to prevent repetition of kind of these defamatory claims. That's something that human rights tribunal can do, I think, and I think can do it more effectively than the criminal law. And often I think what victims in these situations really is just want this person kind of to shut up, right? They want this person to stop spreading hate. And I think, through a cease and desist order, which is something a human rights tribunal can, issue, that can be a more targeted way of sort of kind of silencing the hate monger, which is, I think, often really what the victim community wants, as opposed to necessarily seeing the hate monger punished. And then also there's other advantages, like the human rights tribunal can offer mediation services. So rather than kind of proceeding to an adversarial context, there's the opportunity for mediation, which sometimes victims would want more, let's say, than an adversarial or criminal justice approach. So all those reasons, I'm in favor of, alternatives to the criminal law. But I think, Richard kind of put his finger on really the core question here, which is, will this be effective at, targeting hate speech, remedying this big problem of hate speech and hate crime that we're dealing with? And I'm not sure that it will, for some of the reasons that, echo things I said with respect to the criminal law. As Richard pointed out, our previous iteration of Section 13, it wasn't used very often. And actually, it's interesting because there's been a lot of concerns being raised about kind of a flood of complaints, but at least under the old provisions, actually, as I think Richard knows, there weren't that many complaints, and not a lot of them ended up proceeding to hearings. There was a few sort of highly publicized ones that got a lot of attention, but in actuality, I don't know how much that is a concern. And there's also some provisions that have been talked about in terms of sort of dismissing vexatious complaints that the government has proposed in this legislation, and also awarding costs, against frivolous complaints that might help to limit the number of frivolous complaints. But the flip side of that is, if there's not that many people actually being brought before this body, how effective can it be? I'll leave it there. I have other thoughts, but I'll leave it there in the interest of time.
Well, this reminds me why we really needed 2 hours to have this discussion. And then I think that this perfectly, tees it up for you, Sunil, if you can offer your thoughts.
Yeah, I agree with so much of what Ken has said about access to justice for disadvantaged communities, this being faster, more flexible, lower standard of proof, mediation, non-adversarial environment. There are more safeguards, as have been pointed out. I agree with all of them. The concern, okay, what if this isn't used enough? I think we're putting too much stock on the legislation, right? That's not the fault of the way the bill is drafted as it relates to the Canadian Human Rights Act changes. What that means is, it has to be accompanied by efforts to empower equity deserving groups. How do we make sure that Black, Indigenous people, Muslim people, Jewish people, queer folks, trans folks, how do we make sure they use this provision? That's the bigger question, right? And that can be through education, like public legal education, right? It could be providing legal resources to these communities. What if legal aid, helped with these complaints, for example? Like, those are real important questions. So let's not throw the baby away with the bathwater. I think there are more safeguards here. I think the real key is empowering folks from equity deserving groups so that it's actually used, because it can be effective.
That's an important point. I think that that is really a separate question, and that's something that can be developed over time. So it's not about drafting. That's just about kind of structuring and education and different victim support that can be provided and resourcing in different ways. Thank you, everyone. Taylor, maybe you can bring it home.
Yeah, sure. I mean, I've just been listening and learning so much in the last hour. So thank you, everybody. I mean, just two minor observations from my perspective, being much more involved on the regulatory side of this and the statutory model that's the duty to act responsibly, which is most of this bill. The lucky thing about this conversation about these legal provisions is they don't need to solve all the problems. That's the point of the rest of the model, which is it shouldn't be the criminal justice system or the human rights tribunals. Actually, there should be a burden placed on those that run, design, and profit from the platforms themselves to reduce the spread and risk of hate speech, as well as 6 other forms of harmful content. Right. So like that cannot be said enough, I think, that like the biggest piece of this bill is putting that responsibility to minimize risk, do risk assessments, be more transparent on the platforms themselves to minimize this harm. The question then I would have is like, is there still a place in addition to those for these other changes and provisions? The good news is I don't think they have to do all of the work here, and the bar can't be do these things solve all of the problem of hate speech? And of course they won't, nor will the broader bill solve all of the problem of hate speech, but can we minimize collectively across these various mechanisms the harms that we know are real? But look, that's my editorializing in the last moment of this. But so thank you, everybody. And really just to Sunil, Kenneth, Richard, Sandy, and especially to Emily to guiding us through this. Thank you. We have a couple more of these planned. There will be one on bringing some international perspective to this. So people who have built similar models in the UK, Australia, EU, we're going to do a panel on that. There will be one on the kids-specific protections within the Online Harms Act. And any ideas, we're open to ideas for others. We're just going to keep having these conversations because at the very least for us, it's interesting, and hopefully to a broad range of others. So thank you all for joining us, and we will see you again in the coming weeks.